Agenda item 16 is status update and possible commission guidance on amended initial statement of reasons for section 238.5 of Title 14, which deals with the stocking of aquaculture products. Mr. Scott Barrow from the department is going to come and give an overview on this. While Scott is coming up, I want to tell you that by way of background, at your meeting in October this past year in San Diego, Commissioners, you authorized staff to publish notice of your intent to consider amendments to Section 238.5 of Title 14 regarding stocking of aquaculture products. You also directed the department to modify the existing initial statement of reasons at that point regarding permit fee structure and what we'll call management of biological analysis. This item is scheduled now for the department to outline its modifications to that initial statement of reasons and for the Commission to provide you additional guidance if necessary. And as I said earlier, Mr. Scott Barrow is here from the department. I hope I didn't tell the whole story, Scott. Go ahead.
No, you just led up to it. Again, I'm Scott Barrow with the Fisheries Branch. Good morning. I'm going to give you a short presentation on where we're at today, and then we'll take public comment. Nancy Murray will be joining me a little bit later. She's on the shuttle, so she'll be here shortly. This is the private stocking permit, section 2385. What you see on the first map is the part in yellow is the part of California that is presently exempted from asking for a stocking permit for stocking various species from aquaculturists. As you see, there's a pretty good chunk of California that's exempt at this point in time. So basically, as John mentioned, October 21st, we brought the ISOR back to you. You asked for the three things: update the permit fee to recover department's costs, address the management of biological surveys done for the pre-stocking evaluation, and also discuss the proposed changes with the industry. Since then, we've been having numerous conversations with the industry reps, director level, aquaculture the development level, and on February 9th, we got a counter proposal of what they would like to see in our regulations. So I'll give you a quick overview of that. They would like to maintain the current low fees such that to attract more customers. They also want to be able to make the stocking permit effective for 5 years so it matches the same effective duration of the pre-stocking evaluation. They want to have no implementation of the pre-stocking evaluation protocol at this time. They want to have a faster application process. And they want to have a pre-approved list of registered aquaculturists who can stock without pre-notification of the department. They would like a simplified appeal process for permit denials, concurrent implementation of Phase 1 and Phase 2. Phase 1 was the pre-stocking evaluation and removing the exemption. Phase 2 was the invasive species and disease monitoring aspects. They also are looking for a new permit to allow farm and private fishing ponds to be stocked without a stocking permit. They would also like that these same ponds to be able to allow anglers to fish without a sport fishing license. So we went back and discussed these, and basically we have the list of 9 here, and on the responses is the number that corresponds to them. There's 3 items that we can easily address in the ISOR at this point in time. Low fee structure, provided that it also covers the department cost. We're talking about developing a tiered structure, a basic fee of $145,000, and then increments as more time involved for travel or for review. We think running the 5-year permit duration to match the pre-stocking evaluation duration, provided nothing changes in the initial conditions, that's fine. We've added a department application review process such that prior to coming to the commission process, the commission appeal process, that it undergoes a higher level review within the department at the director level or maybe the regional manager level. So maybe we can solve some of the issues before coming to the commission process. So the next level these are items we feel we can address without regulations. A faster application process. That's just getting enough staff and time to be able to make this prioritization to have this happen. Developing a pre-approved list of registered aquaculturists. We could probably do that fairly easily. Now here comes the part that's not so fun. Phase 2 is not ready. There's a lot more discussions that have to go on with the aquaculture development, the disease committee. And so we feel that phase 1 isn't ready, phase 2 isn't ready, phase 1 needs to be implemented to protect the resources. So therefore, in their item of asking for no implementation of the pre-stocking evaluation protocol, we feel we don't have the leeway to be able to honor that at this time. And that's a measure that's been called for by the EIR, EIS, and we feel that we need to apply that. Concurrent implementation of phase 1 and phase 2 measures, we feel by waiting for this concurrence, this happening at the same time, it was going to affect natural resources dramatically, and we felt that we couldn't comply with that request. The items that can't be addressed in regulation, a new permit to allow farm ponds and private ponds to be stocked without a private stocking permit. We don't have that ability to offer that waiver at this time under statute, because statute 6400 says everybody must be permitted unless you guys allows for a change. They're also asking for a whole new category in that with the farm and private ponds, they also, number 9, want to be able to allow their customers to fish without sport fishing license. The only person in California besides a person who has a private pond without any connections to the waters of the state, they can allow sport fishing without a license, but the only other person in California is registered aquaculturists. That's an exemption that's allowed by statute, and we can't change that. So if we want to allow anybody else to be able to fish without a fishing license outside of the two free fishing days, we have to go to the legislature. So again, here's the revised 2001 permit fee structure. We looked at the application of 2 hours review from a ES rating C, and 1 hour of processing by an office tech. Comes to about $149. That includes overhead, that includes benefits, also includes the ALDS surcharge. So for the review, simpler process, a couple hours review and processing, $91. So if we're trying to build a permit fee that handles everything across the state is so vast and so broad that's almost impossible, because in some areas it takes 3 or 4 hours to drive to get to these points from our office. So unlike I did with the restricted species permits, we had just one set fee throughout the state. We decided trying to keep the initial fee low so that any additional review time that's required for maybe have a troubled species, maybe they have an area that has a lot more decision species around in it, that any additional hour would be charged at $58 an hour. And so if we have to drive and drive to the travel for the inspections, that would be about $95 an hour. So, for example, if a gentleman has more than 2 hours review time, of course, it would have built up accordingly, but that would allow us to offer the lowest rate possible, depending on how close they are to the office or how far away they are from the office. And so basically under survey management, department survey, as we talked before, we would love to be able to do these, and we will do these if we have the ability, but that has to be at the local regional discretion. The next level is consultant surveys with visual encounter survey only. There's no pre-authorization needed, but they must follow and use appropriate methods and protocols for that species and that location. And then we're also asking for a final report detailing the survey methods and results. For a consultant who involves using sampling gear, we're looking for a current MOU or letter of authorization with the department. And then pretty much everything else is the same as the previous consultant survey. Documentation of qualifications and species and locations being surveyed, and a final report. We feel that consultants who surveys involving federally listed species, if they're qualified with a federal agency, we'll accept that as qualification for our purposes. And with that, our next steps where we're talking today is we feel we're ready to go with the ISOR and file it upon what you've asked for at the last meeting. Or option 2 is continue discussions with the industry and present results at a future FGC meeting. And that's the end of my presentation. I'll answer any questions at this time or whatever your wishes.
I think we'll wait for public comment before we have questions.
Okay, Mr. President, I have a number of public commenters on this. I think it's a total of 9. As you said before, it's 3 minutes per commenter. I have Mr. George Osborne, followed by Douglas Elliott, followed by Ken Beer. Mr. Osborne.
Thank you, Mr. President. George Osborne, representing the California Association for Recreational Fishing. The letter being handed out now you previously should have received. I met with the director. We've met with the department and the director a number of times having these discussions. In a meeting with the director on Monday of this week, he told me that his recommendation to this commission would be that they file these regulations tomorrow. Okay. In that same conversation, Mr. Mastrup indicated that the regulations as they are written today are a work in process. Okay. We agree that they are a work in process and therefore should not be filed. One example of that would be, you recall the map where you see this large expanse of exempted counties. Perhaps there could be an area-wide permit so that each of the persons who own ponds and stock ponds, etc., in this area would qualify for an area-wide permit rather than having to go through the process of hiring a consultant, coming on their private property, doing the inspection, and incurring the expense of that. Okay, we're certainly willing to continue to work with the department in developing, language for that. But again, as a work in process, we don't think these regulations should be filed, and we would ask the Commission to allow us to continue to work. On the one hand, the department is asking us through the AG's office to agree to a later trial date on the court case. I guess there are a number of cases involving this issue. And on the other hand, telling us that they're going to file the regulations. We would like for you, please, to direct the department, should it be your pleasure, to allow us a 120-day comment period whenever you do direct the department to file these regulations, such that we can have time to get experts and appropriate testimony before you for your consideration. Pardon me. Additionally, we would like for you not to adopt these regulations until such time as the trial court has decided, and that may be early next year. And again, the AGs ask us to agree to a delay on the trial until that time period, and we're willing to do that, but we would certainly, again, appreciate something back from the department in return for that. This would allow us to continue to work with the department as we have been. We've made some progress. We think we can make some more. We intend to do that, and that's what the Commission has directed, and we would ask your concurrence in continuing that process. Thank you, and if you have any questions, I'm happy to answer them. Thank you, sir.
Mr. Douglas Elliott. Mr. Elliott, is Mr. Alexander wanting to cede time to you still?
Yes, he is, sir. He's right there.
Mr. President, he's asking for some cede time, 5 minutes.
Thank you.
Go ahead, Mr. Elliott. And before you start, though, Ken Beer, and I'm sorry I can't read this next card. Somebody from CARF, and you're going to have to do a better job of talking than you write when it comes time.